Let's resume. The tribunal first addresses the application made by the claimants in respect to the new documentation. What the tribunal is going to do is not to make any formal decision whether to admit or reject this document. And by document, we understand it relates to the 8 pages to be proffered by the claimant. What we're going to do is to invite the claimant to give us the relevant document, and we'll receive it de beni esse. We don't at the moment understand its relevance either to the claimant's case or to the respondent's case. And so in the oral submissions to come this afternoon, we're going to invite the claimant to explain its relevance to their submissions with the document before us, and only then shall we make a decision whether to admit or reject the document after hearing further the respondents. So that's the basis of the decision. It's de beni esse only, and the respondent's objection is fully preserved.
Thank you, Mr. Chairman. Should we hand out copies of the document now?
Yes, please.
Copies of the FAM. Okay. Ms. Ferrante is going to go get the copies. Mr. Chairman, just bring them down. They were left upstairs accidentally.
Do you want to wait for that document, or can you proceed with your other submissions now?
She'll be back shortly, so we can proceed.
Please proceed.
Mr. Chairman, good afternoon, members of the Tribunal. Thank you for this opportunity. As so often happens with closing remarks on the heels of a tight hearing, our presentation will be more like less like a Mozart-like symphony and more akin to a Freddie Mercury Queen-type Bohemian Rhapsody. We too have tried to strictly adhere to the Chairman's exhortation that we not regurgitate what we've already stated in our written pleadings and in our opening remarks on Monday. And by organizing ourselves on the basis of the less is more principle, we sincerely hope that we're not going to leave the Tribunal wanting in terms of the issues that need to be clarified. In any event, we certainly intend to elaborate on all of the issues that we'll be discussing with you in this closing, on the questions that you have raised, as well as any other issues that we identify that are of importance after we've had an opportunity to examine the record with less tired and quieter minds. We also make the same reservations that respondent did with the request to supplementing our responses when we present our written submissions. I can seldom recall an arbitration in which I have featured so prominently or my name mentioned as frequently. It almost reminds me of Ali Foreman 1 in Kinshasa, and we all recall what Ali did to Foreman in round 8 of that fight, and I think we are now in round 8. But given that I'm only a middleweight and not a heavyweight, I am going to be assisted by my 2 law partners who will be assisting with this closing presentation. We're going to start off with Mr. Posner, who will address what we learned from Mr. Parada's testimony on cross-examination yesterday. Mr. de Grammont will then address a few factual issues that perhaps warrant clarification, and in the process will address the factual issues that you raised yesterday in your questions. And then we intend to address your various questions pretty much in the order in which you presented them to us yesterday afternoon. So with that, Mr. President, I will turn the floor over to Mr. Posner.
Good afternoon, Mr. President, members of the Tribunal. It's an honor to appear before you once again. As Mr. Ali has said, I'm going to make some observations about the testimony of Mr. Parada and their relevance to the case. Now, at the heart of that testimony, of Mr. Parada's testimony, is a very serious accusation directed at two of my law partners, Mr. Ali and Mr. DeGramont, two seasoned attorneys, the chair and vice chair, respectively, of Kroll and Mooring's international arbitration practice, and highly regarded members of the arbitration bar. The accusation is that in the course of a screening interview for a lateral associate position, Mr. Ali and Mr. DeGramont revealed to Mr. Parada confidential information regarding a client's intention to initiate arbitration against the government of El Salvador. Now, that accusation is patently preposterous. That was clear from the face of Mr. Parada's witness statement, and it became clearer still over the course of Mr. Parada's testimony yesterday. Why would two senior attorneys each independently reveal to a lateral associate candidate whom they were meeting for the first time their strategy for addressing a client's problem? Why, in the course of a screening interview, would they tell someone with deep ties to the government of El Salvador that they were planning to initiate arbitration against the government? It simply makes no sense. Now, Mr. Parada told us his theory as to why these client confidences would have been revealed, and he says, and I quote from page 314 of yesterday's transcript, "And I concluded that perhaps knowing my relationship with El Salvador, they were wanting me to relay that information to El Salvador so El Salvador would know that there was international arbitration law firm already preparing an ICSID case against them, and therefore they would try to avoid going to arbitration and give in to whatever the company wanted. That was my conclusion." Now, Mr. Parada says he came to this conclusion even though he admitted that he did not know Mr. Ali previously, that this was a screening interview for a lateral position arranged by a headhunter, and that Mr. Ali never revealed the name of the client, the amount of damages the client sought, or any sense of when the client intended to file for arbitration if its demands were not met. Apparently, Mr. Parada was supposed to intuit this critical information omitted by Mr. Ali and deliver the message supplemented by his own intuition to his government contacts. Moreover, Mr. Parada believes that Mr. Ali told him that he, that is, Mr. Ali, had personally told the president of El Salvador of his plan to bring ICSID arbitration against the government, a statement which, if true, would seem to obviate any need to use Mr. Parada to communicate that message. And I refer here, Mr. President, to page 327 of yesterday's transcript. And with regard to this meeting with President Saca that Mr. Ali supposedly told Mr. Parada about, I would remind the tribunal that despite his original claim to have, and I quote, very precise information that, if true, would completely undermine everything, Mr. Parada admitted that he has been unable to locate any documents confirming that such a meeting took place. Mr. President, I submit to you this is the stuff of conspiracy theories. It is not evidence, and certainly not evidence that could even arguably be probative of any issue in this proceeding. But that is just the tip of the iceberg when it comes to the implausibility of Mr. Parada's testimony. I will point to just a few other indicators of its utter lack of credibility. First, in his witness statement, that is the original written witness statement that Mr. Parada submitted, Mr. Parada testified that the client confidence divulged to him by Messrs. DeGramont and Ali were revealed, and I quote, during our first meeting. That comes from paragraph 6 of the witness statement. Yet in his testimony yesterday at page 295, he was less sure, and this time he says, they gave that information to me at the very latest on the second meeting we had on December 7th of 2007. But he then went on to qualify that testimony further. He qualified his accusation by stating with respect to Mr. DeGramont, and I quote again from page 304 of the transcript, it may have been that I mentioned to him what I had been told, that is, what he had been told by Mr. Ali, and he confirmed it. All of this, despite stating under oath that he had been precise in preparing his witness statement, and that occurs at page 371 of yesterday's transcript. Now, second, despite supposedly having learned from Messrs. DeGramont and Ali confidential information about impending arbitration against the government of El Salvador, a government, I remind you, in which he had worked for 15 years, including in senior positions, a government that had been a client of his, a government with which he continued to have very strong ties. In none of Mr. Parada's communications with the government or with his own colleagues at Dewey LaBeouf did he mention how he came by this information. Although he apparently was trying to win the government as a client, in none of his communications did he mention that he had learned about impending arbitration against the government directly from counsel for the would-be claimant. Indeed, none of Mr. Parada's contemporaneous communications say anything about having learned of the impending arbitration from counsel for the would-be claimant. The first time he says that he learned about the impending arbitration from Mr. Ali and Mr. de Gramont is in the witness statement submitted in this case long after becoming an advocate for the government of El Salvador. And by the way, the lack of any reference to Mr. Ali, to Mr. de Gramont, to the law firm of Kroll and Mooring in any of Mr. Parada's contemporaneous communications is all the more remarkable given his admission that he felt, and I quote, no duty of confidentiality after terminating discussions about potential employment with Kroll and Mooring in March of 2008. And this appears at page 293 of yesterday's transcript and at various other places in the record as well, in addition to appearing in paragraph 9 of Mr. Parada's witness statement. Now, if indeed Mr. Parada felt no duty of confidentiality, why would he have failed to mention the source of the information he had learned about impending arbitration against El Salvador in communications with close contacts with the government or with his own colleagues? Moreover, Mr. Parada's emails to the government starting in March 2008 don't even mention Pacific Rim. It is not until July of 2008, when the possibility of arbitration between Pacific Rim and El Salvador was being widely reported, that Pac Rim is named in Mr. Parada's correspondence. His earlier emails are so general and lacking in information that, as Mr. Parada admitted, one could not tell whether they were alluding to a possible dispute with Pac Rim or some other dispute. And as we know, another dispute under CAFTA, also involving a United States mining company, was in the making during precisely this time period. That, of course, was the Commerce Group dispute. Now, third, Mr. Parada testified that even though Messrs. Ali and de Gramont did not tell him the identity of the client whose litigation strategy they were divulging to him, he was able to infer the identity. In particular, he testifies at page 318 of yesterday's transcript, and I quote, I was aware that there was a mining dispute in the brewing. I was aware that the company was Canadian. I assumed that was the case they were talking about. Mr. Parada then added, I believe with perhaps 90% certainty that I told them that I believe this arbitration may be started by the individual U.S. investors because that was what I immediately believed when I first heard, and that's at page 319 of the transcript. Now, on his account, not only did he instantly understand exactly who and what Mr. Ali was talking about, but he was already fully informed as to the client's nationality and as to its shareholding structure. Not only that, but he was able instantly to identify a solution to a jurisdictional problem that he identified, analyzed, and resolved during the course of a brief screening interview. Nonetheless, when writing to a contact in the Salvadoran Ministry of Foreign Affairs 8 months later, in July of 2008, following press reports of the impending arbitration, Mr. Parada stated that he had, and I quote, just completed preliminary research and found that the company in question, Pacific Rim Mining, is Canadian, not a U.S. national. In other words, he had just completed his preliminary research in July 2008, that is after the press reports came out. And this is reflected in Annex K to his witness statement, as well as at page 365 of yesterday's transcript. In short, Mr. President, the core story behind the core story that Mr. Parada tells makes no sense. It is fraught with internal inconsistencies, and it is exceedingly far-fetched, if not downright ridiculous. But setting all of that to one side, putting all of that to one side, if we take Mr. Parada at his word, his own contemporaneous understanding of what Mr. Ali and Mr. DeGramont said to him, undermines rather than helps respondent's argument. And thus, in his first email to the Assistant for the Attorney General, this is the email from March 7th, 2008 that we discussed at some length yesterday. This is Annex D to Mr. Prada's witness statement. In that email, Mr. Prada refers to the matter not as a dispute, but as a possible international dispute in the making at this time that may result in an international ICSID arbitration against El Salvador. Let me repeat that because that really bears emphasis. It's not a dispute. He didn't understand it to be a dispute. He understood it to be a possible dispute in the making that may result in ICSID arbitration. Thrice qualified. I can't think of any more ways you could possibly qualify that characterization of the dispute as Mr. Prada understood it at the time, as reflected in a contemporaneous email, as opposed to a document created once he became an advocate for El Salvador in this case. It really is hard to imagine any more ways one could qualify that characterization. In Mr. Prada's own words, what he understood to be the situation in March of 2008 was not that a dispute had arisen between Pac Rim and El Salvador. He understood, based on what he says he learned from my partners, Mr. Ali and Mr. DeGramont, that there was a possible dispute in the making. In other words, the circumstances as he understood them at the time, in his own words, were such that they might ripen into a dispute. On the other hand, they might not ripen into a dispute and might or might not result in international arbitration. Now, later emails we reviewed, in addition to that March of 2008 email, we reviewed several other emails yesterday, and those later emails do nothing to salvage respondent's case. Yesterday we looked at Mr. Prada's July 9th, 2008 email, Annex K to his witness statement, and that says that it definitely seems like they, meaning Pacific Rim Mining Corp., are laying the groundwork to initiate arbitration in the medium term if their plans are not approved. Thus, even as late as July of 2008, Mr. Prada is still expressing uncertainty. Even at that date, the situation has not advanced much beyond the possible dispute in the making that may result in arbitration. In other words, Mr. President, the contemporaneous documents Mr. Prada has produced only confirm Claimant's position that no dispute arose until sometime in 2008. Now, as we have explained, it was only in March of 2008 that the dispute even began to crystallize after President Saca's revelation of the de facto ban on mining permits. Before that, while Pac Rim Cayman may have been unhappy at the delays in getting a response to its applications for permits, it did not have a dispute with El Salvador. Mr. Prada has said nothing that in any way suggests otherwise. Mr. President, before I turn the podium over to Mr. DeGramont, I'd like to make one last point. We would like the tribunal to take note of Mr. Prada's highly charged statements that he was seeking further information on Mr. Ali's supposed private meeting with President Saca, information that he said, and I quote, would completely undermine everything, and which he said he feared would prejudice the tribunal if he were to reveal it here in the context of this hearing. And that's at pages 320 and 324 of yesterday's transcript. Claimant respectfully requests that the tribunal order respondent to produce the results of Mr. Prada's investigation as soon as possible, but certainly no later than May 20th. If respondent is unable to uncover this purported information, claimant requests the tribunal to order respondent to write a letter of explanation and apology to the tribunal and claimant for the insinuations and innuendos Mr. Prada offered on this point yesterday. I thank you, and I'll now turn the podium over to Mr. DeGramont.
Thank you, Mr. President. Good afternoon, Professor Stern, Professor Tawil. As Mr. Ali stated, I am going to briefly review what we've learned about the relevant facts in the past couple of days. From the perspective of the relevant facts, we really didn't learn much that was new that has any bearing on the issues before the tribunal during the course of the past 2 days. We've learned a couple of things, and I will mention those in passing. But what is noteworthy is that all of the facts that Claimant offered and that Respondent didn't even try to rebut, that Respondent often failed even to mention, that Respondent often tried to steer the tribunal's attention away from. So let's take a quick overview of the key unrebutted facts that remain unrebutted and that we believe are dispositive of Respondent's objections. Can I have the next slide? Okay. Here are the basic undisputed facts about Pac Rim Cayman. Pac Rim Cayman was established in 1997 at the direction of Mr. Shrake from his office in Reno, Nevada. Undisputed. Pac Rim Cayman was always substantially managed by Mr. Shrake from his office in Reno, Nevada. That's undisputed, and I'll discuss that a little bit further. Mr. Shrake in Reno was primarily responsible for deciding what assets Pac Rim acquired, what assets Pac Rim disposed of, and how those assets were managed. Undisputed. Pac Rim Cayman was domesticated to Nevada at the direction of Mr. Shrake. Undisputed. All of the direct investments of financial capital made by the companies into El Salvador were accounted for through Pac Rim Cayman beginning in 2004. Mr. Bedini says, what's the evidence of that? Read the testimony of the current CFO at paragraph 27. Quote, from 30 November 2004, all of the company's direct financial capital in El Salvador were made through Pac Rim Cayman, unquote. Respondent had the opportunity to cross-examine the CFO. It chose not to do so. A substantial portion of the financial capital invested into El Salvador through Pac Rim Cayman was of U.S. origin. It came from U.S. mining operations. It came from shareholders with addresses of record in the United States. Undisputed. Pac Rim Cayman was registered as the investor owning Press and Dorix with El Salvador's National Office of Investment. Undisputed. Pac Rim Cayman has been the 100% owner of Pacific Rim Exploration, a Nevada corporation, since the December 2000 reorganization. Undisputed. Now, Respondent's response to all of this is, well, there was nothing to manage. It's just a pure paper company. This is a company that owned, acquired, and disposed of millions of dollars of assets. Now, all legal entities are legal fictions. They are often given substance only through the people who control them, who decide what and where the company is going to invest. A trust or a sole proprietorship may not have offices or employees, but they are specifically defined as enterprises under CAFTA. They are legal entities whose investment decisions can be made by a single person, without furniture, without employees, without UCC filings. Again, the undisputed evidence is that over the years, Pac Rim Cayman acquired key assets of the company. It disposed of some of the assets of the companies. Funds from those assets were then reinvested in other assets owned or acquired by Pac Rim Cayman. Now, did those investment decisions, often involving millions of dollars, just happen by magic? Did Pac Rim Cayman, this paper company, somehow make those decisions by itself? Sort of like the computer HAL in the movie 2001. Good news, Mr. Shrake. This is Pac Rim Cayman reporting, and I'm happy to tell you that I've just put all your money in El Salvador. Of course not. A human being had to make those decisions. A human being had to give the company substance by making its investment decisions. That human being was Mr. Shrake, a U.S. citizen who from his offices in Nevada decided that millions of dollars from the company's entities, many of them U.S. entities, would be redirected from those entities and invested through Pac Rim Cayman in El Salvador. This was a company that was given substance by people. Here, really, the person who made its decisions. It was given substance by the capital that flowed through it, which was principally of U.S. origin. It was given substance by the assets it owned, both in El Salvador and, since December 2007, in the United States. Again, that's more than a year and a half before this arbitration commenced. Now, Mr. Benini said, oh, Pac Rim Cayman has no mining operations. Either does Pacific Rim Mining Corp. Pacific Rim Mining Corp is a company of accountants and investment experts. Dayton Mining US has no mining operations. It's a holding company. It holds the assets of another mining company. It generated millions of dollars that was invested through Pac Rim Cayman into El Salvador. How did the money get there? Mr. Schrake directed it there from Nevada. The next slide. All of the evidence concerning the broader Pac Rim family of companies, of which Pac Rim Cayman is an integrated part, is also undisputed. Mr. Bedini referred to the putative connections with the United States. They're not putative. They're undisputed, and they are substantial. And the gravamen of the respondents' objections is that a paper company was set up by an investor with no ties to the relevant jurisdiction. In fact, in substance, this was a U.S. investor and a U.S. investment. That's relevant not only to the denial of benefits, but also to the abusive process, the whole underlying principle of which is to avoid investors with no connection to a jurisdiction setting up a paper company and trying to take advantage of that pure formality. So what's the evidence concerning the Pac Rim companies? Mr. Schrake, the president and CEO of Pacific Rim Mining Corp., always maintained his office in Nevada. Dayton Mining US of Nevada owned mining operations in Nevada that generated over $20 million that was invested into Pac Rim Cayman. Pacific Rim Exploration, another Nevada corporation, served as the exploration arm of the companies. A majority of the shareholders of the Pacific Rim Mining Corp have addresses of record in the United States. These are substantial U.S. connections. Now, I suppose if Pac Rim Cayman had been transported from Nevada to the Cayman Islands, because Cayman Islands had some sort of treaty and there were no ties to the Cayman Islands, maybe this would be a different case. This is a case where the domestication reflected the actual economic and managerial substance that had existed for years. To apply the denial of benefits or the abusive process objections here would be to turn the principles underlying those objections on their head. The next slide. Now, what about the numerous statements by El Salvador's successive presidents, President Saca and President Funes, regarding the de facto ban? We didn't hear anything about that. Respondent talked about the initial March 2008 report, but what about all the other statements? We didn't hear a word, not a word. I will not grant mining permits. President Saca, July 2008. President Saca, quote, will not grant a single permit, unquote. President Funes, the government is not approving any mining exploration or exploitation project. President Funes, no mining exploitation projects will be authorized. Minister Dada, the government has, quote, provided continuity to the decision to not issue mining permits, which was made during the administration of President Saca, unquote. We didn't hear anything about those from the respondent. They didn't try to explain them. They didn't even mention them. They tried to distract your attention away from them because they understand that there is a practice not to grant mining permits no matter how meritorious they are. This is fundamentally different from delays, and counsel knows that. What about El Salvador's continued reassurances to the companies? We didn't hear anything about those. Mr. Schrake testified that there were numerous representations by the government that the process was moving forward, that respondent intended to comply with the existing laws. Mr. Smith said nothing in December 2007. There's testimony about a meeting that Pacific Rim had in January 2008. In January of 2007. There was testimony given yesterday by Mr. Schrake about a trip he took to Chile in November of 2007 with key members of the legislature so that they could look at a mine that was similar in design to El Dorado. Reassurances can come not only in the form of words, but actions as well. After the first alleged presumptive denial in 2004, there was an extended notice and comment period and an extended exchange of observations and responses on El Dorado's EIA that went on from 2004 to 2006. Respondent never addresses that or explains how that could possibly be consistent with a presumptive denial in 2004, because it's not conceivably consistent. There's no explanation as to how you can reconcile those two things. The environmental regulatory process was moving forward on other sites, Pueblo and Huaco, in 2007 through 2008. Indeed, Marn requested Dorex to provide comments on Marn's observations to the Pueblos EIA in January of 2008. Again, that's undisputed. There's the letter from Marn in December 2008 asking for more information. This is December 2008, asking for more information so that it could move forward on the El Dorado EIA. That's nearly 2 years after the alternative presumptive denial in 2007. Not a word from Respondent's counsel to explain that letter. What about El Salvador's missing witnesses? All of these witnesses were referred to multiple times in the testimony of our witnesses and our documents. Where's Ms. Gina Navas, the director of the Bureau of Mines? Where's Mr. Ernesto Javier Figueroa Ruiz, the author of the 4 December 2008 letter asking for more information so that they could continue the El Dorado permitting process? Where's Vice President de Escobar and Minister de Gaviria, who gave assurances to the companies that the laws of El Salvador would be followed? Where's Mr. Guillermo Antonio Gallegos, the majority leader of El Salvador's Congress, who led a delegation to visit Mr. Schrake in Nevada, and who in January 2008 told Mr. Schrake that legislative amendments were likely to be passed and that the permits were likely to be granted? Where's the Marn minister, Mr. Guerrero Contreras, who was at the meeting with Mr. Schrake and President Saca in June 2008? Why were none of these witnesses called to rebut Mr. Schrake's testimony? Mr. Smith said that we submitted a letter 2 weeks ago mentioning a dinner that Mr. Schrake had appeared in, had attended in January 2008, and only if they had known about it, they would have talked to these witnesses. The guests at that dinner included Ms. Gaviria, Ms. de Escobar. They had numerous opportunities to talk to these witnesses. They either chose not to do so or they chose not to present them to this tribunal. Now, yesterday, the tribunal asked us whether it should draw an adverse inference from the fact that we did not present the testimony of Ms. Hashimoto. And that's a fair question. The rules apply equally to both parties. But let's take a look at the respective roles of these witnesses. There is, I believe, a single reference to Ms. Hashimoto in Mr. Schrake's witness statement other than her being laid off. It says, quote, "At some point in 2007, our then Chief Financial Officer, Ms. April Hashimoto, suggested to me that we could cut costs by deactivating subsidiaries in jurisdictions where the companies had not conducted business for some time, but where we still paid various fees and costs and devoted administrative time in order to maintain the business in good standing." Again, as Mr. Shrake testified, this was one of at least two reasons for the reorganization. And the fact is...
If I can interrupt, what seems to be significant about that piece of evidence is that it relates to the initiative, the timing of this change. And if you look at that paragraph, it looks as though the idea came from Ms. Hashimoto. Is there any other evidence that it came or originated from any other person?
Well, Mr. Krause testified that he reviewed the books and records, that he spoke to KPMG.
He wasn't there at the time.
And Ms. McLeod-Seltzer didn't testify about the origin, but she testified about that reason.
She's a very senior officer. Is
You know,
it your case that it originated with her?
That's what Mr. Shrake testified to. For all we know, Ms. Hashimoto got it from another employee.
This is not necessarily a point against you.
Yeah, no, I understand. I mean, the position of the company is, well, we never considered that who came up with the idea, who within the companies came up with that idea, was an interesting question. I mean, certainly the respondent didn't ask Mr. Shrake about who originated that particular idea. The fact that that was one of the reasons is corroborated by our other company witnesses. I mean, we offered 3 witnesses, all of whom are still affiliated with the company. Ms. Hashimoto is not affiliated with the company. I mean, I suppose we could have tracked down all of the employees who had been laid off and interviewed them, and we could have tried to put them on, and we could have tried to put on the members of the board, and we could have tried to put on people from KPMG. That would have become an expensive endeavor, and I'm not sure how much it would have added. I'm going to skip over the next 2 slides are simply the portions of the witness statement from Ms. McLeod-Seltzer and Mr. Krause, corroborating that one of the ideas, one of the reasons for the reorganization was to cut costs. And I'm going to go to the investment into El Salvador slide. Now, you've seen this slide before, and I will not linger on it. The fact is that there is no explanation from the respondent as to why Claimant would have continued to invest into El Salvador if it thought that there was a pre-existing dispute. Next slide, please. One more key fact on when a dispute arose or crystallized, and my colleagues will address the legal meaning of that shortly, involves when the company first perceived that it was being damaged. A dispute doesn't begin to arise until the loss complained of arises. Regulatory delays were frustrating. The imposition of the ban was devastating. This chart shows the share price of the company versus that of an index selected by respondent. And what you can see is that the company's share price closely tracked that of the rest of the industry through March 2008. It began to depart from the rest of the industry following the March 2008 announcement. In July, which was following Mr. Saca's meeting with, or rather Mr. Schrake's meeting with President Saca, and Mr. Schrake's decision to shut down the drills, they fell dramatically and never recovered. Now, no one testified that suddenly March 2008, we knew that there was a ban in place. What we have argued is that through 2008, the process seemed to be moving forward, albeit with delays and bumps. Through 2008, respondents' representatives were representing that the process would go forward and that the permits would be granted. In March 2008, suddenly the head of state, after all this has happened, after $77 million has been invested in the company, after years of working on this project, with a regulatory framework in place, the president of the country says, I oppose mining permits. Mr. Schrake wrote to President Saca and said, I read that you oppose mining permits. Can that be right? We have rights under CAFTA. And the discussion continued. Mr. Schrake met with officials, including President Saca himself, in July 2008. And if you read Mr. Schrake's testimony, it was at that moment that he decided to, after the July meeting, that he decided to shut down the drills and begin layoffs. It wasn't until 6 months after that that we filed the notice of intent. Could we look at the next slide? We didn't hear very much from respondent on the argument that they had made concerning the resubmission of the application. They made that argument repeatedly in their briefs. For example, in the memorial, they said, indeed, Claimant could have resubmitted its application for an environmental permit after CAFTA entered into force. In the reply, they said, as El Salvador noted in its memorial, Claimant could have submitted another application for an environmental permit, but it has not. How can you reconcile those statements with the repeated statements by President Saca and Funes that no permits would be granted? You can't reconcile them. And therein lies the difference between regulatory delays and potential differences over regulatory requirements, and a practice not to grant mining permits regardless of the regulatory requirements. If I go and apply for a permit and the agency says, oh, we grant those in 7 days, come back in a week, you'll be fine. I come back, they say, sorry, we're still working on it, we're working really hard, we're really backed up, come back in a week. Come back in a week, oh, we're still working on it, we'll get it done, don't worry. This goes on for several weeks, I come back and they say, oh, guess what? We're not giving those permits anymore. We decided not to issue them anymore. Suddenly that puts the prior delays in a very different light. There were two factual questions posed by the tribunal. The first one, if I understand it correctly, was, is there other evidence that a private placement was undertaken in early 2008? And so I would direct the tribunal's attention to the first document that's in our binder, which is Claimant's Exhibit 33. These are excerpts from the 2008 Pacific Rim Mining Corp annual report. The entire report is, of course, available to you in the exhibits. And I direct you to page 3. And there's a bullet point down under overview. It says, on February 29th, 2008, the company closed a private placement finance offering in which gross proceeds of roughly 7 million Canadian were raised through the issuance of 6.7 million units consisting of 1 share and 1 share purchase warrant. So that's additional evidence that there was the private placement financing, and 2 points arise from that. First, why would the company undertake a private placement financing if they thought they were already embroiled in a dispute? Second, if the companies thought that there was a dispute, they would have had to disclose that. I mean, take a look at page 21. Under controls and procedures, disclosure controls and procedures. Management has designed disclosure controls and procedures, or has caused them to be designed under its supervision to provide reasonable assurance that material information related to the company is gathered and reported to senior management, including the Chief Executive Officer and the Chief Financial Officer, as appropriate to permit timely decisions regarding public disclosure. In the US and in Canada, there are very strict securities laws and rules that any material fact has to be disclosed to potential investors. There is no record that a dispute was disclosed to investors prior to this private placement financing. And
we go back to page 3. There's a reference to a section 7.3. Do we have that?
I'm sorry, Mr. President, where is this?
Page 3. If you look at the bullet that's highlighted, beginning on February 29. Do you see that on page 3? And then the last line refers to a section 7.3.
We do have it in the actual exhibit. And
if we have it there, we'll find it. Don't worry.
Okay. Again, we took the tribunal's admonition not to kill any more trees seriously, so these are just excerpts that I wanted to point out to the tribunal. The whole document is in the complete exhibits. And we, this is one of many, many points we made regarding the absence of evidence that a dispute concerning this measure existed at this time. But we simply would like to suggest to the tribunal that it is extraordinarily unlikely that these experienced directors would have failed to disclose a dispute prior to the private placement financing if they had believed a dispute existed. That would have been an extraordinary risk for them to do. And what you'll see in this report, which is dated July 2008, and I suspect this was written slightly before, well, if you look at page 2, it says in the highlighted language, unfortunately, permitting risk remains an unresolved issue. While at the beginning of fiscal 2008, we appeared to be experiencing the normal hiccups associated with stewarding a mining permit through its often complicated process, the apparent lack of willingness on the part of the El Salvadoran government throughout the past year to finalize approval of our El Dorado environmental impact study and otherwise meet its responsibilities associated with our mining permit application has caused the company to take stock of its future options. And then several paragraphs down, it says that the company may pursue our legal options under El Salvadoran law and international treaties, including CAFTA. There's no disclosure like that prior to March 2008.
Just pausing, we've now found paragraph 7.3, and it's self-explanatory, but it does refer to something, speaking for myself, I don't understand. The private placement was conducted on a best efforts / commercially reasonable basis. That's obviously a term of art, but I don't know what it means. Do you?
I don't either, Mr. President. We'd be happy to address that in our closing submission.
Why don't you do that?
Okay, thank you. The second factual question that the tribunal asked was whether Pac Rim Cayman maintained its corporate personality through the domestication to Nevada. And the answer is yes, and I will explain that. Under the doctrine of corporate migration, a company can migrate from one jurisdiction to another without losing its corporate personality if both jurisdictions recognize the doctrine. That's what happened in Aguas del Tenari. The investor migrated a holding company from the Cayman Islands to Luxembourg. Both the Cayman Islands and Luxembourg permitted this migration and recognized the continuation in corporate personality. And so it was permissible both for the purposes of local law as well as for the purposes of establishing jurisdiction. Here, both the Cayman Islands and Nevada recognized the doctrine of corporate migration and the continuation of corporate personality. Let's look at the documents. And the first is a tab 2 in your binder. It's Respondents Exhibit 68. And I will confess that it's only somewhat helpful because on the second page, under Pac Rim Cayman, it says, notice is hereby given pursuant to Section 229 Companies Law, whereby the following companies have been deregistered in the Cayman Islands and transferred by way of continuance to Peru. Now, Mr. Schrake made a comment about trying to administer things in the Cayman Islands, and I suggest this may be evidence of that. So let's keep on going through the documents. Tab 3. This is Respondents Exhibit 69. And this was the document that I tried to find during my opening and wasn't able to, but let's look at it now. Again, Articles of Domestication. The name of the entity is Pac Rim Cayman, LLC, a Nevada limited liability company. The entity name before filing Articles of Domestication, Pac Rim Cayman. Date and jurisdiction of creation. Date of creation, September 10, 1997. And the jurisdiction that constituted the principal place of business, central administration, or equivalent of the undomesticated entity before the Articles of Domestication was Cayman and Islands. So this indicates that for a filing fee of $350, the company could be domesticated to Nevada and would continue its corporate identity there. Let's take a look at tab 4. Now this doesn't have an exhibit number. It's tab 13 from a binder that was submitted with the respondent's memorial. It's the respondent submitted as a binder that accompanied its memorial, claimant's entire document production of 6 October 2010. That's referenced in their memorial. We're happy to give it a exhibit number, whether it's respondents or claimants, but it is in the record before the tribunal. And the first document is a written resolution of the sole shareholder of the company. And paragraph 1 says, pursuant to Article 107A of the company's Articles of Association, an application be made to register the companies for the deregistration to the registrar of the companies. I'm going way too fast, aren't I? An application be made to the registrar of companies for the deregistration of the company in the Cayman Islands and its transfer by way of continuation to the state of Nevada. Okay, the next page is the Articles of Organization. And in the Cayman Islands, the company actually did have a board of directors, as we'll see in a moment. When it was domesticated to Nevada, it instead had 2 managers who at the time were Mr. Schrake, and you can see his address here in Reno, Nevada, and Ms. McLeod Seltzer. We have the Articles of Domestication again. Then we have the affidavit of Wendy Husu on behalf of Woodridge Corporation in its capacity as a corporate director in the matter of Pac Rim Cayman. And among the statements in the affidavit, the company is able to pay its debts as they fall due. This is Pac Rim Cayman. The application for deregistration is bona fide and not intended to defraud creditors of the company. The transfer is permitted by and has been approved in accordance with the company's memorandum and Articles of Association. The laws of the state of Nevada, United States of America, with respect to the transfer have been or will be complied with. And the company will, upon registration under the laws of the state of Nevada, United States of America, continue as a body corporate limited by shares. After that, you have the interim unconsolidated balance sheet, which shows that Pac Rim Cayman had assets of approximately $52 million and liabilities of approximately $42 million. A few pages after that, you have the corporate director's undertaking, and this is again Ms. Husu. who undertakes on behalf of the said corporate director to give notice to the secured creditors of the company of the transfer of the company to the state of Nevada. And then after that, you have written resolutions of the directors of the company, passed in accordance with the Articles of Association of the company. And it says, number one, continuation of the company in the state of Nevada, USA. It is noted that a proposal has been put to the directors of the company to continue the company in the state of Nevada, and accordingly to change the name of the company to include the suffix LLC, and to amend the company's memorandum and articles of association to comply with the laws of the state of Nevada, USA. And the proposal has been carefully reviewed by the directors and is considered to be in the best interest of the company. And the directors wish to recommend that the sole shareholder of the company, to the sole shareholder of the company, that the company be continued under the laws of Nevada, etc. Now, so the company had a board of directors. It's a corporate formality. Again, the real person who was making this decision was Mr. Schrake. And again, the whole point of the exercise that we undertake in abusive process and denial of benefits is to look beyond the corporate formalities, to look to where the real control resided. In vacuum salt, the tribunal looked to the chief executive, the person who, quote, steered the company's forces. And we will submit that if you look beyond the rigidities of corporate structure, if you look to the real substance of this investor and this investment, you will see that the investor and the investment is substantially a U.S. investor and a U.S. investment. Finally, I included as a tab 6 and 7, Mr. Galen's application to register the foreign investment, which had been in the name of Pac Rim Cayman of the Cayman Islands, to Pac Rim Cayman of Nevada. And again, there's the resolution resolving to effectuate that domestication. I include those primarily for the reason that I find it so galling that we have been repeatedly accused of hiding this from El Salvador and from the tribunal when these documents have long been in the record, when one of them was attached as Exhibit 3 to our notice of arbitration. I would submit that that kind of accusation in the face of obvious evidence to the contrary is unfortunately indicative of the way that respondent has chosen to conduct its defense of this case. With that, I'll turn this over to my colleagues.
Don't disappear just yet. We have a question. We'll come back to it. Thank you.
Thank you, Mr. Chairman.
Maybe take about 2 minutes.
We can certainly take 2 minutes for you and even more. Let's take 5. We're going to resume the hearing, but we have a certain difficulty with the feed, and I'm going to ask the Secretary to the Tribunal to explain what's happened.
Well, we have, with apologies, we have been advised that the World Bank server is down. They're trying to upload it. There was an alleged threat to the system. So our suggestion, subject to the tribunal and the parties, is to record the remaining part of the hearing while they try to fix it. That is one option. Or the other option is to wait until the server is up and running again. But at this point, we don't know for sure when will that happen.
I suggest that we continue, because we understand that technicians will continue to record the hearing, and then when the feed is re-established, the transmission can resume, so it will still be public. But it leads us to another question that the tribunal considered last night, and that is the status of the transcript. We obviously wish to make available the transcript of this hearing, including today's closing oral submissions, to the non-disputing CAFTA parties. And unless there's some objection from the parties, we will do this. We also need to ask what the parties would wish us to do as regards the amici. They certainly will hear the hearing, but would it be appropriate for one or both of the parties or ICSID to make available the transcript to the amici? Can I throw that out? We don't need an answer yet, but before we depart this evening, we need to come back to the status of the transcript. So unless there's some objection, let's continue, and if the feed resumes, it will resume if and when it does.
Very good. Thank you, Mr. President, members of the tribunal. I'm back at the podium. To address the topic of the measure at issue as it relates to the abuse of process objection and the objection to jurisdiction ratione personae. In the course of my comments, I hope to respond, at least in a preliminary fashion, to the first issue that the tribunal raised yesterday under the heading of abuse of process. We'll then depart a little bit from the order that Mr. Ali described at the beginning of our remarks. Rather than have Mr. Ali come up after I speak and address various topics, I'll stay at the podium and continue on with the subject of denial of benefits and address several of the issues that have been raised under that heading. So first on the subject of measure at issue. Now, there's been, I think, some confusion over the course of these proceedings as to what the relevant facts are for purposes of abuse of process and what the relevant facts are for purposes of jurisdiction ratione temporis. So let me be very clear at the outset. The question of when the dispute arose, is not relevant to the determination whether the tribunal has jurisdiction ratione temporis. It may be relevant to an abuse of process analysis, but it is not relevant to a jurisdiction ratione temporis analysis. As we discussed in our opening submission, and I'm not going to regurgitate that submission, but as we discussed there, CAFTA's temporal to scope is defined by reference to when acts, facts, and situations occurred. CAFTA incorporates the customary international law rule of non-retroactivity, which is set forth, in quotes, for greater certainty in Article 10.1.3 of CAFTA. And under that rule, as I put it earlier in this hearing, the treaty's entry into force effectively draws a dividing line. And if an act or fact took place after entry into force, if it takes place on that side of the dividing line, it is covered by CAFTA. If a situation began before entry into force but continued after entry into force, again, if it's on that side of the dividing line, it is covered by CAFTA. Now, there are investment treaties that define their scope and coverage by reference to when a dispute arose, and we've discussed a couple of those treaties in our counter memorial at paragraphs 220 to 223. That is, those treaties expressly exclude disputes arising prior to the treaty's entry into force. We discussed a couple of those treaties, as I mentioned, but CAFTA is not one of them. So in principle, even if a dispute arose prior to CAFTA's entry into force, or in this case, prior to CAFTA's becoming applicable to the claimant, the dispute could be submitted to CAFTA arbitration as long as it involved a situation that continued after entry into force. Now, as we've stated repeatedly over the course of the past 3 days, the measure at issue in this case is a practice that may well have begun before CAFTA entered into force as to the claimant, but that came to light as a practice only when President Saca publicly confirmed its existence in March of 2008, and that practice continued after entry into force, that is, after CAFTA became applicable to claimant, and in fact that practice continues to this very day. And that practice, just to emphasize the point so there's no confusion on this issue, that practice is the withholding of permits and licenses necessary for metallic mining regardless of the applicant's compliance with relevant laws and regulations. And as a shorthand label, we refer to this practice as the de facto mining ban. Now, let me be very, very clear about this. President Saca's statement of March 2011 is not the measure at issue. That is not the measure at issue. We have never alleged that it is the measure at issue. His statement is confirmation of the existence of the practice that is the measure at issue. It shed light on the practice, but that does not mean that it is the practice. Now, CAFTA defines measure, the term measure, in Article 2.1, and it defines it to include any law, regulation, procedure, requirement, or practice. CAFTA does not define the term practice, but as explained in our counter memorial, the ordinary meaning of practice is, and I quote from the dictionary as quoted in our counter memorial at paragraph 408, footnote 492, a practice is a repeated or customary action or the usual way of doing something. The repeated or customary action that constitutes the practice at issue in this case consists of various acts and omissions which result in the non-issuance of metallic mining-related permits despite the requirements of Salvadoran law. Now, prior to President Saca's announcement, prior to that March 2008 public statement, Claimant did not know, and indeed Claimant did not have reason to know, that the acts and omissions through which permits were denied to Press and Dorex constituted the practice that is the measure at issue. From all outward appearances, those acts... Yes, Mr. Teller.
Please, finish your sentence.
I was going to say, from all outward appearances, those acts and omissions were just instances of ordinary delay.
Mr. Posner, can you develop a little bit more how 1013 would work with a change of nationality?
Well, let's start with the basic proposition in 1013. So the focus in 1013, and as I said earlier, it's really just a repetition of Article 28 of the Vienna Convention on the Law of Treaties, is the basic non-retroactivity principle, and it's focused on entry into force of the treaty. We're sort of taking one step away from that, and we're saying we're focusing not on when the treaty entered into force for the whole world, for these two capital P parties, the United States and El Salvador, but when it became applicable to a given investor. So before an investor becomes a person of a party, the treaty is not applicable to it. From the moment it becomes a person of a party, the treaty is applicable to it. So if we think about this in terms of that dividing line that I described earlier, the dividing line in this case is the moment at which the person acquires the nationality of a party. So at the moment you've acquired the nationality of a party, assuming that at some earlier stage you were a national of a non-party, the Cayman Islands or any other country that's not a party to CAFTA, if you acquire the nationality of a party, if you become a U.S. person, whether by domesticating in the United States, if you're a corporate entity, or if you're a natural person, if you acquire citizenship, from that point, that's where the line is. And if the act, fact, or situation occurred before that line comes into existence, before you acquired the nationality, then the treaty doesn't apply to you unless it's a situation that began before you acquired the nationality and continued or did not cease to exist after you acquired the nationality. Does that answer your question?
Would there be any change if instead of changing nationality, the same company would, a new company from the U.S. have acquired the asset? I mean, you had a continuing measures or conducts or whatever, and instead of having the same company change its nationality, you had a new company from the U.S. buying the assets. Would that be the same situation?
So let me just make sure I understand the hypothetical correctly. So in the situation you're describing, at the first point in time, the asset is owned by a person of a non-party.
Mm-hmm.
And then subsequently, the asset's acquired by a person of a party.
while the contact has been steady in time. I mean, a continuing contact.
Right. And I suppose, one question that might arise in that hypothetical, I think really goes to the merits rather than to jurisdiction. I mean, if, for example, we're talking about a claim of denial of fair and equitable treatment, and the merit of that claim hinges on the investor's legitimate expectations. If the investor who acquired that investment, the person of a party who acquired the asset, is aware of the situation that might hypothetically be the basis for a claim of denial of fair and equitable treatment, then I would suppose that would go to the merits and might alter your view of...
So you're sustaining that for purposes of jurisdiction there would be no difference?
I believe for purposes of jurisdiction, again, the focus has to be on the measure, and it's the measure as it relates to some point in time. With respect to persons who are persons of a party and who were persons of a party on the date of entry into force, the two temporal points are identical. It's only when we're talking about a person who acquires U.S. nationality or who acquires the nationality of a party at some date after the treaty entered into force that those 2 points in time are different, and we need to focus on the point at which the person acquired U.S. nationality. But I would say, with respect to somebody who was a U.S. national, who was a U.S. national,
Who was or who was not?
I'm sorry, in your hypothetical, let me take a step back. Let's remember, too, that the scope is defined by reference to acts, facts, and situations, but it's also defined by reference to investors and covered investments. So in the hypothetical you've described, at the moment prior to the acquisition of that asset by the U.S. national, there is no covered investment. It only becomes a covered investment. That investment only takes on the status of a covered investment when it's acquired by a U.S. national. So the treaty wouldn't even apply to that investment until the investment is acquired by an investor who's a person of a party.
So it would be the same situation as a change of nationality?
I believe, as I'm standing here, I believe that's right. I believe the answer would be you would have the same situation. I'd like to reflect on that a bit more and perhaps elaborate on that in our post-hearing brief.
Thank you.
Just to come back to the distinction I'm drawing here between what appeared to be the case before Claimant became aware of the measure at issue and what the reality that took hold once the Claimant became aware of the measure at issue. It was only when viewed from the perspective of President Saca's announcement that it became evident that the acts and omissions that led up to the claimants becoming aware of the practice were indeed part of a more general practice. And it is true, and Respondent has really hit on this point over and over again over the course of these proceedings. It is true that we've sometimes referred to the individual acts and omissions that resulted in the denial of permits to Press and Dorix as measures. We sometimes use the term measures to describe those acts and omissions. And they are indeed measures. That is an accurate way to describe those acts and omissions, but they are not the measure at issue. And I think that's a very important distinction to make. The measure at issue, and I really want to emphasize that phrase, the measure at issue, that is the measure that is the basis for claimant's articulation of breaches by Respondent of obligations on the international law plane, is the practice of withholding mining-related permits. It is that measure that forms the basis for our claims of expropriation, denial of fair and equitable treatment, and denial of national treatment. It is that measure that gives rise to the damages for which we seek compensation. In short, it is that measure that forms the basis for a dispute, as that term is used in CAFTA. Now, as I said, it is...
Can you put a date on this?
A date on...
The measure at issue.
Well, the measure at issue is the practice.
For the purpose of your claim.
Yes. So
liability, causation, quantum.
Right.
The date.
The moment at which Pac Rim Cayman became aware of the measure at issue, the moment it became aware of that.
That wasn't my question.
Okay.
You're making a claim
Yes.
under CAFTA. You say the relevant measure is the measure at issue.
Yes.
What is the date?
And yes, it is difficult to tell you precisely the date on which that measure came into existence. I can tell you the date on which Claimant became aware of its existence, and that is March 2008. So approximately in March 2008, Claimant became aware that this practice existed as a practice. But because the nature of this practice is an unwritten practice, it's an unwritten measure that consists of a series of acts and omissions that only through the light of President Saca's statement only through the light of that statement does it become apparent that they sort of have a cohesive existence as a practice, as components of a practice. Only at that moment does Claimant become aware that there is a measure that forms the foundation for its claim of breach.
If CAFTA had come into effect only in February 2008, would you have a claim?
I believe we would, because here we're talking about a practice that is a situation that began in your hypothetical, Mr. President, would have begun before entry into force, but continued after entry into force. It did not cease to exist.
And in those circumstances, when you were pleading an unlawful measure in March 2008, could you go back in time to put it into context?
Absolutely.
Before February 2008?
Absolutely, and indeed we did that, and I'll come to that in a moment, because I think some of the confusion here, or some of the confusion that respondent has created around the notice of intent and the notice of arbitration stems from the reference to various acts and omissions which we accurately described as measures giving rise to the ultimate claim. It is true that they gave rise to the claim in that they created the foundation. They were there. We don't deny that those delays, that those, as Mr. de Grammont said earlier, those frustrating delays, missed deadlines, those various acts and omissions existed. Yes, they existed. But they only became cognizable as the measure at issue when the measure at issue became apparent, which wasn't until March of 2008 at the earliest. I think that the distinction that I'm making here, Mr. President, between measures and the measure at issue is a very important one, and I think to avoid any confusion, I think an illustration might help to clarify the point. And we actually gave a small illustration in our counter memorial. I realize that the length of these written briefs has been quite long, and it may be it may be that this illustration didn't get the full attention it deserved. But in our counter memorial, we referred to a case in the World Trade Organization concerning a practice that was alleged to be a measure. And I'm smiling a little bit because I'm sure my former USTR colleagues at the back of the room are smiling about my reference to a World Trade Organization case in the context of an investor-state arbitration. But I think the relevance will become evident momentarily. Now, the case I'm talking about concerned a complaint by the United States about an alleged de facto moratorium in the European Union on the marketing of biotechnology products. It was a very famous case at the time, and you may well be familiar with it. There was no regulation imposing this moratorium, but certain EU member state representatives consistently voted in a way that resulted in the rejection of applications for the marketing of biotech products. Now, the United States challenged the de facto moratorium as opposed to the individual rejections of marketing applications that made up the moratorium. It was the moratorium that was the measure at issue. And indeed, the WTO panel agreed with that characterization of the moratorium. That is, the panel agreed that it was the moratorium that was the measure at issue, and it found that, and I quote, and even though it's hard to read on the screen, I assure you that the quotation is up there. The general de facto moratorium on approvals constitutes a challengeable EC measure. Now, in making that finding, the panel observed that, and again, it's quoted up there, although I know it's going to be hard to read, the moratorium is a measure which is the result of other measures, meaning decisions. In other words, the individual decisions, it was acknowledged, are measures. They meet the definition of measures. But the moratorium as such was not cognizable until you'd had sort of an accumulation of these measures, these individual component or constituent measures only over time, and as the result of various public statements by the member states involved in those decisions, did it become evident that there was this practice, this moratorium, of which these individual decisions, these individual acts and omissions were a part.
Maybe to follow up on the same line, because this, I think, is quite a crucial issue. You state, in a way, if I understand you correctly, that a practice is a series of measures. So do you consider that a claimant can base its claim on acts that occurred before the time that claimant could invoke the protection of CAFTA? And if so, because you are speaking about continuing measure, I remember that in your counter memorial, in paragraph 163, you were speaking about continuing or composite acts or omissions. Do you still base your reasoning on that? And if so, is it rather a continuing or a composite act, which, as you know, are not exactly the same?
I believe, Professor Stern, that... Thank you. Part of the difficulty in characterizing the measure, whether as an act or fact that occurred at a moment in time, or as you rightly point out, we propose in our counter memorial a continuing or composite act. Part of the difficulty in characterizing it is that it's not a written measure, it's not a statute, it's not a regulation. So one has to examine the conduct of the instrumentalities of the Salvadoran government over time to make that determination. I believe, as we stated in our counter memorial, that it is accurate to describe this practice as either a composite act or a composite act or a continuing act. I believe that that would be a fair characterization for the reasons we described in our counter memorial. I think it's also possible, and again, we just don't know because the information we have is the information we derive from our own experience interacting with the government over time. But I believe you could also describe it as an act or fact that came into existence, if you will, in March of 2008. That's possible. I don't know the answer with any precision because we don't know precisely at what moment this measure was put in place. So I can't tell you with any certainty that those prior acts and omissions that even at that early date, even back in 2004, or Mr. Smith, I think, said earlier that there hasn't been a permit granted in El Salvador 2003. I can't say with any certainty whether it was at that moment in time that the measure was put in place. And so I believe that based on the information we have, any one of those characterizations may indeed be an accurate characterization of the practice. But I would submit that for purposes of the tribunal's ratione temporis determination, you don't need to decide which of those it is. The fact is, the clear fact is, it is one of those. It either is a continuing or composite measure, or it is an act, fact, or situation that took place, occurred for the first time at the moment when President Saca formally said in March of 2008, this is the practice. This is going to be the way our agencies conduct themselves going forward.
To answer part of my question, saying that you don't know exactly when the practice started. Okay, let's take this as you said. But one aspect of my question was whether in a continuing practice you can take into account for a claim acts that existed before you are protected.
Yes.
I mean, it's quite a simple question.
Yes,
Not very
and
easy
the
to
answer is
answer,
yes.
But it's
Yes, you can. The answer is yes. You can take them into account, and indeed, we've done that. In our notice of intent and in our notice of arbitration, we've described those earlier acts and omissions because they're quite relevant as context and as background for understanding the practice that only came to light subsequently. So yes, indeed, we can take them into account. But let me be very clear. With respect to our claim for damages, we're only asking damages as a result of the breach that we became aware of and that we only could have become aware of as of March 2008 at the earliest. So when I say we're relying on those earlier acts and omissions, we're relying on them because they appear to be part of the practice that is the measure at issue.
And the last question I don't ask you to answer now because it might need you some more time, but maybe in your post-hearing brief. As I said, you said continuing or composite, but you didn't choose. I mean, it's either one or the other. It cannot be the two. Well, I mean, it has it has very precise meaning in international law. So
yes.
If you could elaborate on that in your post-hearing brief.
We will absolutely do that. Let me just to close out on this point, and then I'm going to walk through a bit our notice of intent and our notice of arbitration and discuss a bit how we've identified the measure at issue there. But before I turn to that, just to close out on this point and why I brought this the EU biotech case to your attention as sort of an analogy, the reason is that the situation described there, where you have a measure at issue that consists of component measures, in that case a moratorium that consists of a series of decisions, is really very much akin to the situation we have here. In this case, the de facto mining ban is a measure which is the result of other measures. In the biotech case, again, it was not immediately evident that the individual rejections of marketing approvals were part of a broader moratorium. It was only in view of repeated conduct over time and other evidence that it became apparent. The same is true here. Now, as I said, respondent alleges that in our notice of intent and in our notice of arbitration, we've been less than clear on this point. In their view, those documents characterize individual acts and omissions that took place prior to December 2007 as the measure at issue. And I will admit, Mr. President, members of the tribunal, that we could have been clearer in our drafting of the notices. We do not claim perfection or infallibility when it comes to the drafting of the notices. However, even if we did not articulate our claims as clearly in those documents as we did in more recent submissions, we have been consistent throughout this case. In particular, and why don't we move to the next? Okay. In particular, we consistently have rested our claims of breach of CAFTA obligations, as well as our claims of breach of the investment law obligations, on respondents' practice of withholding metallic mining-related permits despite the requirements of Salvadoran law. In our opening statement on Monday, I called your attention to paragraph 9 of our notice of arbitration. And given respondents' contention that we have changed the measure at issue in response to its objections, it's worth recalling what is stated in that paragraph. And I realize time is short, but let me just read it briefly to remind you that indeed we do identify the measure at issue in the manner I've just described. What it says at paragraph 9 is this: only after President Saca's announcement in March 2008 did they, meaning press and Dorex, understand that they had become the target of something other than bureaucratic delay or incompetence. Rather, President Saca, without any legal or other valid reason, had simply decided to shut the enterprises down and deprive them of their substantial and long-term investments. As a result of the government's actions and inactions, the rights held by the enterprises have been rendered virtually valueless, and PRC's investments in El Salvador have been effectively destroyed. Now, in the interest of time, I won't read out the other places in our notices where we've made similar statements, but I will describe them to you, or I'll give you the citations, and at its leisure, I would invite the tribunal to go back and read those. I refer in particular to paragraphs 73 through 81 of the Notice of Arbitration, as well as paragraph 32 of the notice of intent. And again, in the interest of time, I'm not going to read through all of those statements, but I submit to you that they identify the measure at issue precisely as I have just described it to you, and as Claimant has described it to you consistently throughout this arbitration. Now, that is why Claimant, contrary to what Respondent alleged in its opening presentation on Monday, concluded the factual recitation of its notice of intent by referring to President Saca's March 2008 statement and noting that Claimant commenced negotiations with the government in relation to its permits in light of President Saca's comments. So while, as I said, we could have been clearer, I won't contest that. We have indeed been consistent. But even to the extent that we were not as precise as we could have been, we recall the tribunal's observations in its decision on the preliminary objections that a notice of arbitration, and I quote from paragraph 99, cannot be equated to the fine-tuned instrument which emerges at the later stages of ICSID arbitration proceedings. I submit to you that our written submissions, I hope the tribunal views our written submissions as that fine-tuned instrument, and in any event we urge, and again in the tribunal's words, we urge that the notice should not be judged by a formalistic standard more appropriate to a later pleading. Finally, before I move on to denial of benefits, let me just emphasize in response to the tribunal's question as to whether the measure at issue is the same for the CAFTA claims and the investment law claims. It is. In both cases, the measure at issue is the de facto mining ban. Also, as I said earlier, in both cases, Claimant is alleging damages only from the period from March 2008 forward and not from any earlier period. I'm going to take a brief drink of water here and then turn to denial of benefits. And on denial of benefits, Mr. President, I'm only going to address two brief points in response to topics 4 and 5 under that heading that the tribunal raised yesterday. With respect to substantial business activities, I believe our submission to you over the past 3 days is complete, certainly further amplified by Mr. de Gramont's remarks earlier this afternoon. And so I'm going to focus on the question concerning ownership that the tribunal raised yesterday. I'm also going to address the question of the Foreign Affairs Manual document that we've asked to be submitted to the record, and I'm going to respond to a few points that Mr. Badini made with respect to the untimely notice of intent to deny benefits. First, with respect to the topic of ownership and control. Now, we submit that for purposes of the denial of benefits analysis under Article 10.12.2, Pac Rim Cayman is both owned and controlled by U.S. nationals by virtue of the fact that a majority of the shareholders of its parent, Pacific Rim Mining Corp., are persons with addresses in the United States. And for reasons discussed in our written and oral submissions, we maintain that ownership and control of an enterprise by persons of a party defeats any attempt to deny CAFTA benefits to the enterprise, whether that ownership or control is direct or indirect. And the reasons for that have been described earlier in this proceeding. Now, assuming the tribunal agrees with that proposition, the next question, and the one that the tribunal posed yesterday afternoon, is how one determines the nationality of the shareholders of a publicly traded company such as Pacific Rim Mining Corp. And we've suggested to you that an appropriate rule of thumb is the one applied by certain U.S. government agencies confronted with a similar problem. And under that rule of thumb, if a majority of a publicly held company's shareholders have addresses in the United States, the company is deemed to be owned in the majority by citizens of the United States, absent any evidence to the contrary. Now, the tribunals asked us for information on the legal bases for applying this rule of thumb. I would first refer the tribunal to our counter memorial at paragraph 329 and footnote 397, as well as our rejoinder at paragraphs 183 through 185. And let me summarize briefly what's stated there. There we refer to two U.S. government agencies, the Overseas Private Investment Corporation, or OPIC, and the U.S. Agency for International Development, or USAID. Now, let me talk first about OPIC, and you'll see on the screen, even though I know it's hard to read, a page from the OPIC handbook, which has been designated as Claimant's Legal Authority 127. Now, the law establishing OPIC, which is 22 U.S.C. 2198, and we've provided that to you as Claimant's Legal Authority 126, provides that political risk insurance is available only to corporate entities that are, and I quote, substantially beneficially owned by United States citizens. A corporation has to be substantially beneficially owned by United States citizens, not residents, not persons with addresses. The statute says citizens, in order to receive political risk insurance. Now, recognizing the practical impossibility of determining the citizenship of shareholders of publicly traded companies, OPIC applies the law in the following manner. It says, and I quote again from the handbook, and this is what's highlighted on your screen, where shares of stock of a corporation with widely dispersed public ownership are held in the names of trustees or nominees, including stock brokerage firms with addresses in the United States, such shares may be deemed to be owned by U.S. citizens unless the investor has knowledge to the contrary. And this is stated in the handbook at page 17 at the asterisk footnote, which you see highlighted there. And by the way, it's also worth noting that for purposes of the law it administers, OPIC takes into account shareholding by persons with addresses in the United States, whether those shareholdings are direct or indirect. Thus, the last sentence in that same footnote reads, OPIC generally permits the beneficial ownership of U.S. corporations to be determined by tracing back through any foreign ownership of their shares to the ultimate beneficial owners. Of course, that is the same approach we contend the tribunal should take here. Now, Mr. Badini says, well, you have to be guided by the reference in Annex 2.1 of CAFTA, which refers you to the Immigration and Nationality Act. And the Immigration and Nationality Act says that a person is a person of the United States or a national of the United States only if it's a citizen or a person who owes allegiance to the United States. I'll put that to one side. That category is not relevant here. So he says you can only be a citizen, you can only be a person of the United States if you're a citizen. And while we don't disagree with that proposition, it begs the question of how you determine the citizenship of the shareholders of a publicly traded company. And we submit that if U.S. law is relevant to determining the nationality of the shareholders of a corporation, then one must look not only to the black letter of the statute, but also to the manner in which it's applied by the agencies that are tasked with applying it. In the interest of time, I will just identify the other agency and the legal authority. I'm not going to review how that agency administers its law in the same depth, but it is the Agency for International Development. The same principle applies. There are benefits that are eligible to a company only if it's, and I quote, more than 50% beneficially owned by individuals who are citizens of the United States or certain other authorized countries, and USAID applies that same rule of thumb. Now, just to close out on this point before I turn to the untimely notice, the unrebutted Broadridge geographic profiles, which we've provided to you in connection with Mr. Passfield's witness statement, show that a majority of the shareholders of Pacific Rim Mining Corp., i.e. the indirect owners of Pac Rim Cayman, have addresses in the United States, and following the rule of thumb that I've just described to you, Pac Rim Cayman should be considered to be indirectly owned in the majority by U.S. citizens. Now, as I said, let me turn briefly to the issue of notice and the related point regarding the FAM, the Foreign Affairs Manual chapter that we've asked you to admit into the record. Let me first refer to the invitation by El Salvador that Mr. Badini communicated earlier, that it would not challenge U.S. advocacy by the United States government in state-to-state consultations as a breach of Article 27. Well, while that invitation, which now comes more than 24 months after this arbitration has commenced, is interesting, El Salvador does not have the power unilaterally to waive the obligations of the United States under the ICSID Convention. The ICSID Convention is not a bilateral treaty. It is a multilateral treaty, and El Salvador, one party, cannot waive the obligations of another party under a multilateral treaty. That's a basic principle of international law, and I'm sure I don't need to dwell on that further. Moreover, whatever possible comfort this late-breaking information may give to the United States, and I doubt it gives it any at all, it still doesn't change the untenable policy choice that El Salvador's late notice imposes on the United States. El Salvador has put the United States in a predicament, which I described yesterday. Either the United States could invest whatever resources it chooses to invest in this state-to-state dispute settlement process and possibly breach its obligations under Article 27, or it could refrain from doing that and prejudice the interests of a United States investor. But as I pointed out, what possible benefit is to be gained from engaging El Salvador today, 24 months into this arbitration, in state-to-state consultations? El Salvador clearly has committed to its position. Yes?
You just mentioned a state-to-state consultation, but isn't that radically different from diplomatic protection, which is a protection of a national by the state?
Well, it is, that's right. But as I pointed out in our opening submission, diplomatic protection, as that term is used in Article 27, certainly means something more than espousal. Respondents' contention is it's confined to espousal. But as I demonstrated in my statement on Monday, if you interpret diplomatic protection as being confined to espousal, then you render the second phrase, the one that comes after the word or in Article 27.1, a nullity, because that second phrase refers to bringing an international claim. And so if you interpret giving diplomatic protection as espousal, then you're rendering that second phrase a nullity.
But diplomatic protection in the second paragraph of Article 27 is a reference to diplomatic protection in the first, so it's not alternative.
No, sorry, I was referring to in 27.1. Let me read it just so we're clear that we're talking about the same verbiage. So 27.1 says, no contracting state shall give diplomatic protection, and then there's a comma, or bring an international claim in respect of a dispute which one of its nationals and another contracting state shall have consented to submit or shall have submitted to arbitration. Our point is that if you read diplomatic protection to be confined to espousal, then you are rendering the phrase or bring an international claim a nullity. But even more fundamentally, Professor Stern, the concept of diplomatic protection has been understood in other cases to cover concepts broader than espousal. And we gave you a couple of examples of that in a slide from our opening presentation. For example, just to take one example that I know Dr. Tawil is familiar with, in the Duke versus Peru case, you had an investor that had brought a petition. Again, I hate to be picking on my friends in the U.S. Trade Representative's office, but Duke had brought a petition to USTR seeking removal of Peru's trade preferences. And Peru complained. It complained to the tribunal, and it said that's a violation of Article 27, simply for USTR to maintain that petition on its docket, even if it doesn't act on the petition, even if it just lets it sit there on the docket. The mere fact of having it on the docket amounts to the giving of diplomatic protection. It's impermissible, and Peru insisted that it be taken off of the docket. And I give you that illustration to highlight the fact that giving diplomatic protection is widely understood as encompassing conduct much broader than mere espousal, as respondent would have you believe. But even more fundamentally, what would be the point of the United States accepting the grudging invitation that Mr. Badini made earlier today? What would be the point? We're 24 months into this proceeding. There's been a full briefing on denial of benefits. There's been 2 rounds of extensive briefing. We are almost completing an oral hearing here. What would be the United States, what would be the point of the United States sitting across from the table with El Salvador and trying to persuade El Salvador that Pac Rim Cayman has substantial business activities in the United States? It would be a completely futile exercise. And that really goes to the basic, the nub of the issue here, which is that CAFTA was written, and this subject to clause in CAFTA, which we're focused on here, which I remind you was a departure from the template. It was unique for the time. After NAFTA, it had been decided by the United States as a matter of policy not to include that subject to clause, but it was included here on an exceptional basis. And it was included here on an exceptional basis, obviously because the parties, whether it was the United States or whether it was the Central American parties, felt it was important that before a country denies benefits, it goes through these procedural steps, that it gives the other party, that is the other capital P party, the home state of the investor, a meaningful opportunity to engage in state-to-state consultations. Not just a check the box, not just an empty opportunity to do it, but a meaningful opportunity. And by the way, Professor Stern, since you referred to paragraph 2 of Article 27, let me just point something out there, because this is a point that respondent has made in its briefs. They say, well, paragraph 2 of Article 27 says, diplomatic protection for the purposes of paragraph 1 shall not include informal diplomatic exchanges for the sole purpose of facilitating a settlement of the dispute. So the drafters of the ICSID Convention recognize that informal diplomatic exchanges are okay. But Article 20.4 of CAFTA, which is the relevant provision here, isn't about informal diplomatic exchanges. Quite the contrary. Article 20.4 appears in the dispute settlement chapter of CAFTA. It is a formal process. It's commenced through a written request for consultation. Third parties are invited to participate in the consultations. It's much more involved than the informal diplomatic exchange that's contemplated by paragraph 2 of Article 27 of the ICSID Convention. Let me, because I know we're running out of time and there are important questions that I know Mr. Ali wants to address, let me speak briefly to the question of the FAM, which we've asked be admitted in the record of this proceeding, and how it relates to this argument with respect to notice. Now, the FAM, which I think has been distributed to everybody at this point.
We have it and we've read it.
You have? Oh, terrific. Great. Well, so as you know, it's entitled Assistance to Citizens Involved in Commercial, Investment, and Other Business-Related Disputes Abroad. It describes, it's a document that's circulated to officials of the...
To save you time, just tell us why you wanted it.
Why it's relevant. Okay. So the general policy described here is that when a dispute has been submitted to arbitration, the United States takes a hands-off policy. It stays out of it. That is U.S. government policy. That's well known throughout the U.S. government, and it's articulated very clearly here in the FAM. The point is, why would the United States have negotiated a free trade agreement where it provides for state-to-state consultations at a moment, taking place at a moment when the United States, as a matter of long-standing policy, has said it won't engage in state-to-state consultations? What would have been the point of providing for state-to-state consultations at that time in light of U.S. government policy? That's the reason we wanted to put this document before you, Mr. President.
Mr. Posner, are we referring then to paragraph S?
Paragraph S is a key paragraph. I think the document needs to be read as a whole. I think paragraph G is also relevant, but certainly paragraph S is an important paragraph. I think that the FAM is reflective of, as I said, what is a well-known policy throughout the U.S. government. If there are no further questions, I'll turn the podium over to Mr. Ali.
If I may ask the Secretary how much time we have left.
15 minutes.
Thank you very much. Thank you, Mr. Chairman, members of the Tribunal. I will be brief because we do want to reserve some of our time for rebuttal. There isn't much of it, so hopefully at least we'll have at least 5 minutes. I'm going to hit just a couple of points. First of all, I'm going to deal with this question of when is a dispute born versus when does a dispute crystallize, and then I will address a couple of the questions that you've put to us on the investment law, and then a few subsidiary points in advance rebuttal of the presentation that was made by respondents earlier. Now, I wasn't very good at either biology or chemistry when I was in school, so I'm going to stay away in discussing this issue from anything being born or conceived in biological terms or crystallized in chemical or geological terms. I think that those are natural analogies that people might be looking to when they think about this. And, you know, I see some smiles around the room, and Professor Stern, you, I think, appropriately are smiling. But I do think it's important to think about conceptually when one's thinking of being born. I mean, there are hot debates about these issues. So, you know, what I have done is look at all of the cases addressing not only abuse of process arguments, but also jurisdiction ratione temporis in thinking about this issue. And, you know, what are those cases and commentaries? I looked at Professor Schroyer and his recent commentary, in which he says, quote, unquote, here I quote, "The time of the dispute is not identical with the time of the events leading to the dispute. By definition, the incriminated acts must have occurred some time before the dispute. A dispute requires not only the development of the events to a degree where a difference of legal positions can become apparent, but also the existence of a communication between the parties that demonstrates the difference. But also the existence of a communication between the parties that demonstrates the difference," end quote. I also looked at Maffezini versus Spain, Lucchetti versus Peru. I looked at Duke Energy versus Peru, which dealt with the issue of the consummation point of a dispute. I looked at Hellnan. I looked at a number of cases. Now, of course, what I did note from all of these, reviewing all of these cases, is a number of things. First of all, that these are issues that both Professor Stern and Professor Tawil have had occasion to consider before on tribunals in which they have both sat. And we're glad that the chairman will now have an opportunity to address these issues as well, and to join this august club, because it is a very, very difficult issue. Now, different tribunals have used different terminology and different phraseology to address this issue. We will identify the different standards adopted by various tribunals in our written briefing. I don't think I have the time to do it now, but let me make a couple of very quick points. Mr. Smith said that for abuse of process, you shouldn't be looking at when a dispute crystallizes, but when it is born. And in that connection, he referred to Mobile. Now, the facts in Mobile are very clear. We had 3 letters in February, May, and June of 2005 in that case, specifically referring to ICSID arbitration as a means of resolving Mobile's claims or complaints regarding its royalty assessments. So there were communications specifically invoking the instrument of consent. Now, Mr. Smith also acknowledged that there is a separate inquiry for purposes of jurisdiction ratione temporis and abuse of process. We completely agree, and we are actually quite pleased that our opponents have finally understood this clarification, because certainly in their written pleadings, this is an issue that they have confused and we believe purposefully elided the two inquiries, but now have been forced to concede that they are indeed separate inquiries. And then Mr. Smith went on to characterize the Maffesini test for jurisdiction ratione temporis as, I quote, a heightened test. And I'm using his words. So what he's telling you is that there should be a lower standard or perhaps a less rigorous inquiry for the purposes of abuse of process. That can't be right. We would submit to you that it is, in fact, quite the opposite. Now, once you have reviewed our written pleadings on this issue and again and the standards that we'll be putting before you, we think that the following propositions come across very clearly from the cases and commentary, and they are these. Given the severity of the allegation and the severity of the sanction, and here we're dealing with abuse of process, the temporal determination for abuse of process purposes must be made on the basis of evaluating what concrete acts were taken by the party asserting jurisdiction to invoke the instrument on which it intends to base its consent and under which it intends to assert its claims. Now, this need not be a formal assertion of claims in the form of a notice of intent or a BIT notice or a request for arbitration. It can be, as was the case in Mobile, a letter communication invoking the protection of the instrument of consent. The relevant conflict of legal or factual claims bearing on the parties' respective rights, and that phrase, legal or factual claims bearing on the parties' respective rights, I'll put in quotes. It comes from Mavramatis, and it's a standard that you'll see articulated in a variety of the cases. So the relevant conflict of legal or factual claims bearing on the parties' respective rights must be one that gives rise to state responsibility on the international plane, not just the domestic plane. Why? Because what is at issue is an objection regarding the abuse of an instrument of international jurisdiction. And the other proposition that becomes very clear from the different cases and commentary is that, excuse me, the party that is asserting an abuse of process is the party that bears the burden of demonstrating clearly and convincingly that the acts relied upon by the party asserting jurisdiction are not the relevant acts. And we will elaborate on all of these different propositions in our written briefing. Now, let me turn very quickly to consent under the investment law. Now, respondents' attempt to turn your decision in connection with El Salvador's preliminary objections into Hobson's choice sounds catchy at first blush, but they're completely wrong. Based on your earlier conclusion that the arbitration proceedings commenced under CAFTA and the investment law, and I quote, indivisible, being the same single ICSID arbitration, end quote, what they're asking you to find is that because there has been an abusive process of one instrument of consent, you must also necessarily dismiss the claims asserted under the other instrument of consent, even though there has been no abusive process alleged, let alone proven, with respect to that instrument of consent. And here we're talking about the investment law. So this makes no sense whatsoever. They then say that if you decide that there isn't this omnibus dismissal based on abusive process, you must dismiss the investment law claims based on claimant's CAFTA waiver. This also makes no sense. Why? First of all, let's not forget that Pac Rim Cayman could have invoked Article 15 of the investment law when it was a Cayman Islands company in the same way that it is done as a Nevada company. And that's an issue that we address in our written pleading, so I won't dwell on it much further. Secondly, what we have here is one ICSID arbitration based on two separate consents in which different claims are being asserted under two different instruments of international investment protection, and which must be decided under what the tribunal may ultimately determine to be different legal standards, even if those claims arise out of the same common nucleus of facts. So even if you agree with them for some reason that our CAFTA claims should be dismissed, there is no reason whatsoever for also dismissing our investment law claims for lack of jurisdiction unless you have an independent basis for doing so. And we don't believe you do, and we certainly don't believe that there is any basis to dismiss our CAFTA claims for an abuse of process. And finally, your findings on the waiver issue are res judicata. Now, this is a complicated issue. Whenever one starts talking about issue preclusion or preclusive effect or res judicata, the inquiry is necessarily, I believe, best put or addressed in writing. And so we understood the question that you raised yesterday, and if you would indulge us to deal with it in writing, we'd be grateful. Then just a couple of additional points. Mr. Smith in his presentation dealt with the...
Can I stop you?
Yes, sir.
I'm not sure you have understood our point. It's not whether our decision on the waiver is or is not res judicata, but whether the reason which we gave in our decision, namely the indivisibility of these proceedings, is something that we can't or doesn't allow us to review the issue today on its merits, which is the issue of indivisibility invoked by the respondent. We're not seeking to revisit the waiver itself. Now, maybe that's expressed rather unclearly as it was last night, but I'm surprised to hear you say that you're going to allege res judicata in regard to our decision.
Then I may not have understood, we may not have understood the question that was put yesterday. We will re-examine the question as was stated yesterday in light of the comments you've just made, Mr. President. And may I also say that, as I did at the outset, that to the extent that we have made any statements with tired minds in the context of these closing arguments, we have reserved the right to clarify and revisit without prejudice in our written submissions. But thank you for the clarification, and I do think that it's beginning to dawn on me what it is what the import is of your question. Just briefly turning to a couple of very, very quick points. Mr. Smith addressed the withdrawal of this warning letter that we've heard some about, and the withdrawal of a fairly key letter from the El Salvadoran government to our client. But there's absolutely no evidence in the record that this letter was withdrawn. And presumably, as it's their letter, you would assume that they would have been able to provide evidence of its withdrawal, because these are official communications within the process, within the context of a bureaucratic procedure in the truest sense of bureaucracy. So we would imagine they would be able to use some evidence that they had withdrawn this letter, and we would submit to you that it was not withdrawn. But that is an issue to be dealt with on the merits. Mr. Smith focused on language in our notice of intent where we stated that our client's investment was rendered valueless, virtually destroyed. Well, as Mr. de Gramont pointed out, that happened after the meetings in June of 2008. You saw the chart that Mr. de Gramont put up demonstrating the precipitous decline in our client's investment in El Salvador following in the June-July 2008 period and thereafter. And this followed the meeting between Mr. Shrake and the United States ambassador and President Saca and various government officials in El Salvador. The assurances given by President Saca that the that there was that the permits were going to be imminently issued. The subsequent newspaper statements by President Saca that no permits were going to be issued, and Mr. Schrake's consequent shutdown of operations. So that's when the company's share value took a precipitous decline. Now, that's not to say that the company didn't suffer damage as a result of the delays that it had been experiencing over the previous years. But that is an issue for the merits, and as Mr. Posner said, we will be invoking or relying upon facts, acts, omissions that occurred prior to the domestication of Pac Rim Cayman, but our claims don't arise exclusively out of those acts, facts, or omissions. And again, this is a matter that we have addressed in our written pleadings, and we will certainly make this quite clear again, we hope, in our posting submissions. And with that, I will close, because I hope we've been able to reserve some time for a brief rebuttal, but I don't know if that's true.
I think you're overdrawn with the Secretary's...
Okay, well, we will certainly provide some credit then to our opponents.